AEG presents Kathleen Madigan. The stand-up comedian brings her day drinking tour to the Ponte Vedra Concert Hall on Friday and Saturday, December 5th and 6th, 2025 at 7:30 p.m. Tickets available at axs.com. The North Florida TPO is committed to shaping our transportation future. We're focused on planning, funding, clean fuels, and new technologies for a vibrant, connected community. Learn more at northfloridatpo.com. Baptist Health is a proud supporter of First Coast Connect. Baptist Health, committed to building a healthier community for all of us. More info at 202-4YOU or baptistjacks.com.
This is WJCT News 89.9 Jacksonville. Up next, national and local news from NPR and the WJCT News team.
On today's First Coast Connect, should news outlets be required to remove stories about crimes if the charges are later dropped? We talked to a local First Amendment lawyer about the implications of a proposed state crackdown on what the media can publish. Then, a three-part investigation looks at how a weak case and a lying witness landed a man on death row. And 10 people with 5 minutes and a story to tell. We preview an upcoming story slam with a theme of breaking barriers and rules. Join the conversation. Give us a call at 904-549-2937. You can also email firstcoastconnect@wjct.org.
Washington, I'm Corva Coleman. Later today, President Trump is expected to move ahead with his plan to begin dismantling the Department of Education. NPR's Nichole Manna has more.
President Trump plans to sign an executive action that will tell Education Secretary Linda McMahon to take all necessary steps to facilitate the closure of the Department of Education. The move has been expected since early February when the White House shared its intentions, but held off on issuing the action until McMahon was confirmed in her position. The Education Department has already notified nearly half of its staff that they will be laid off. Many of those employees will have their last day of work Friday before being placed on administrative leave. The order also says any programs will not be funded by the department if they, quote, advance DEI or gender ideology. Nichole Manna, NPR News.
A federal judge has denied a request to temporarily block DOJ's takeover of the U.S. Institute of Peace, or USIP. Some former members of USIP had sued the Trump administration. They say they were unlawfully removed from their jobs. DOJ agents used armed law enforcement officers to eject the members, but U.S. District Judge Beryl Howell said there was, quote, confusion in the members' lawsuit. NPR's Ryan Lucas says the judge said she was offended by how the DOJ agents behaved.
She declined to block DOJ's takeover. For now, DOJ will be allowed to remain in control of the U.S. Institute of Peace for the time being as the court continues to consider this lawsuit. But still, Howell made very clear at this hearing that she had very serious concerns about DOJ and how it had gone about gaining access to USIP.
NPR's Ryan Lucas reporting. Another federal judge is giving the Trump administration one more day to answer all his questions about deportation flights last weekend. NPR's Joel Rose reports the Justice Department is fighting the judge's order to submit details about the flights that deported hundreds of Venezuelan migrants to El Salvador.
U.S. District Judge James Boasberg has temporarily blocked the Trump administration from using wartime powers to quickly deport migrants from Venezuela that it accuses of being gang members. Now Boasberg is demanding answers from the Justice Department about whether it deliberately flouted his orders when it allowed 2 deportation flights to continue. But the Justice Department is pushing back. In an emergency filing, lawyers accused Boasberg of, quote, continuing to beat a dead horse. Boasberg agreed to extend his deadline for 24 hours to allow the Justice Department to consider invoking the state secrets privilege. The Justice Department has also appealed Boasberg's orders. Joel Rose, NPR News, Washington.
Hamas is claiming responsibility for rockets fired at Tel Aviv today. The Israeli military says projectiles were fired from southern Gaza. The military says these were intercepted or fell in open areas. This comes as the Israeli military continues to attack Gaza. Hundreds of Palestinians have been killed. This is NPR.
You're listening to WJCT News 89.9 in Jacksonville. Good morning. I'm Stephen Ponson. It's 9:04. 2 men are behind bars in connection with the fiery death of a man found almost 2 years ago in Jacksonville. The Jacksonville Sheriff's Office says 37-year-old Lucius Brown and 24-year-old Xavier Slater were already in jail on other charges, but both are now charged with murder. Police say Brown was also cited for arson in the incident. The case began when officers responded to Lenox Avenue near Luna Street on May 29, 2023, after a person was found in a vehicle that had burned. Evidence gathered and interviews taken by detectives led to the two arrests. Florida lawmakers are moving forward with shielding school districts from a 2023 law that mandates later start times for schools. The requirements are slated to take effect in 2026, but as the deadline nears, many school districts say they are struggling to comply because of things like after-school activities, child care, and the need to buy more school buses and hire more drivers. State Representative Jeff Holcomb of Spring Hill says there's no easy solution.
We all understand the science, and the science makes sense. But this is a logistical nightmare. So at the end of the day, are we going to send our elementary school students to school at 7 a.m.? There really isn't a good answer at all.
Lawmakers okayed changing school start times because of research that said older students need more sleep. If the law goes into effect, high schools couldn't start earlier than 8:30, while middle schools couldn't start before 8. The proposed rollback has gotten the unanimous approval of at least one House subcommittee. Highs in the mid-70s to lower 80s in the area with rain in the forecast.
Support for NPR comes from NPR stations. Other contributors include CFP, Certified Financial Planner Professionals, committed to acting in their clients' best interests. Learn more at letsmakeaplan.org. And the listeners who support this NPR station.
Support for First Coast Connect is provided in part by Baptist Health and North Florida TPO.
Good morning, I'm Ann Schindler, and this is First Coast Connect. Today, a bill that critics say could radically reshape press freedoms is moving through the Florida legislature. We talked to a local First Amendment lawyer about the potential impacts. Later in the program, we talked to the reporter behind a new investigation into the use and consequences of testimony from jailhouse snitches. But first, supporters say it's a bill designed to protect the reputation of the wrongfully accused. Opponents say it would effectively muzzle the media's ability to report on everything from arrests to public meetings. Here to discuss a proposed change to Florida's defamation law is Jennifer Mansfield, First Amendment and media law attorney here in Jacksonville. Good morning, Jennifer.
Good morning.
Nice to have you. This bill would require media outlets to remove false, defamatory, or outdated reports from their websites. Sounds like common sense. What is so wrong with that proposal?
Well, thank you for letting me address that. Traditionally, our defamation law actually came from England. And so if during high school classes, if you saw that the Florida Constitution says that English law prior to July 4th, 1776 is the law of Florida, you might have thought that that was just an arcane reference to the Revolution. But it's actually substantive law that Florida adopted when the United States was created. And traditionally, before the Revolution and up until now, there is no obligation of a defamation defendant to take down material. And if you think about it as a practical matter, in the days of when it was only newspapers and books, to search every library in the country, to cut out an article from every edition of a newspaper that might have been found defamatory after a jury trial is just impractical.
So it would be impractical in the sense of having to go and physically remove, old information, outdated information. But in the modern era, even if it were impractical, what is wrong with the idea of removing information that is false, defamatory, or outdated?
Well, the incident that's prompting this legislation it is a report about, or reports about, a criminal prosecution that someone alleged against a prominent individual, and he claims ruined his life. And eventually the criminal charges were dropped. But he doesn't want the images to be retained on the internet of the reporting about the initial appearance of the criminal court proceedings. And I mean, as a lawyer who represents media, we get those requests all the time because an unfortunate accusation was made, charges were dropped. They don't want their reputation blemished because it comes up in a Google search. But the reporting about the criminal proceeding was accurate. And if you were to have someone who was, for example, potentially abusing the criminal justice system by making false accusations regularly, wouldn't we want to know about that? And if every time charges were dropped, it was erased from the collective memory, there'd be no way to find that pattern.
So this, as you say, it was inspired by a case. It was actually out of South Florida. There was a very prominent CEO, and he was accused of molesting a 6-year-old girl. Very inflammatory accusation. He was accused by the girl's family. In that case, there actually weren't charges filed. So there were not, it was not that they were filed and then dropped. He was null pros. Basically, the state attorney determined there wasn't a buildable case and didn't file charges. He asked the TV stations that reported on it, saying because he couldn't get a job, he lost his job. He asked the TV stations to remove the story, and 2 of them did, and 1 of them would not. What would be the justification to remove it in this case if 2 of the 3 did?
Well, in this day and age, people will take down articles from the internet to avoid litigation because litigation's expensive. And if it's a prominent person who has the wallet to afford litigation, then that could be why. There are a lot of mainstream organizations that will have their own code of ethics internally to their organizations that might also provide for it to be taken down in certain circumstances.
So this man's attorney is his name is Barry Richard. He works with the firm of Greenberg Traurig, who actually represented the George Bush team in 2000. So a very prominent law firm. He spoke at a hearing last week before the Senate Judiciary Committee. Let's hear what he had to say.
The media receives a privilege none of the rest of us have. The privilege says that if they publish a story accurately about an event with no reason to believe that it's false, they get this privilege, which means even if it turns out it was false, they're not liable for it. But it can stay up forever, even when they've learned it is false. How does that make sense? If they weren't entitled to the privilege when they first posted it, if they knew it was false, why should they be able to keep it up forever, knowing that it's false? It just makes no sense, and it can destroy people's lives.
So explain to people who are listening, if I'm not allowed to post something knowing that it's false and receive any protection under the law, why should I be allowed as a reporter to leave up something that I know is false and still enjoy that protection under the law?
I would like to correct the first statement he made.
Okay.
And that it's not a privilege that only the media enjoys. Anyone who speaks about a public figure has the ability to make an honest mistake. And that's the New York Times versus Sullivan decision that people probably heard about. And so for any public official or public figure who's so prominent, the standard is that they have to know that that what they wrote was false, or had a really good reason to believe it was false at the time that they published it. And if that's the case, then they can't be liable for defamation. And it's, as the Supreme Court wrote in that case, it's to give the First Amendment breathing room because people make honest mistakes. Now, he's talking about reporting of allegations against him, and the media, anyone, the media doesn't have a special privilege about defamation law. They tend to be the focus of defamation law because they're often used as a surrogate for the public to attend court proceedings and to go through public documents and report to the public who doesn't have the time to go do that research themselves, right? But everyone enjoys that privilege. And the again, the reporting was not inaccurate, right? The accusation had been made. And his complaint is that the underlying accusation was determined to be false, right? Well, charges were never filed. That doesn't necessarily mean they were determined to be false. But the underlying report of the fact that the investigation was made, that the accusation had been made, were all true. And in today's internet age, it's easier now than ever to follow up, to do follow-up research, to say, oh, whatever happened to that accusation? Whatever happened to that criminal prosecution or civil court case, right? So it's not the report by the media that damaged his reputation. It was the accusation that damaged his reputation.
If you're just joining us, we're talking about a proposal to change reporting freedoms in Florida. It is being discussed by the Florida legislature, and we are talking about it with a local First Amendment lawyer. If you'd like to join the conversation or if you have questions or comments, give us a call at 904-549-2937. You can also email us, firstcoastconnect@wjct.org, or you can reach out on social media. We've got a call from Kate in the Rail Yard District. Good morning, Kate. Go ahead.
Good morning. It just seems so easy in the age of internet when they file a story like this to put some sort of reminder on them to go back and then say what happened. Put at the top of the article, the original article, these people were not found worthy of being charged. Explain the situation so that at least people can't use this against them falsely.
It's a good comment, Kate. And I know that that's something that came up at this hearing last week. Jennifer, one of the representatives of the Florida Press Association, saying that the better requirement is to require publishers to update a story or to publish a correction if that is appropriate. Why is that not just sort of a universal rule?
Well, the First Amendment not only protects what you say, but it also prohibits the government from compelling you to say things. And so a requirement to provide an update would be compelled speech and likely to be held unconstitutional for that reason.
Wouldn't it just be good policy or practice, though, for a news outlet to say we want to make sure that the stories that we have published are accurate?
It probably would. And I think most of the established media entities do that. You'll often see on websites at the end, it'll have hyperlinks to follow-up stories. But I think there's also a practical concern of staffing, right? The news cycle is fast. You write a story, you publish a story, you move on to the next one. You might not hear about the follow-up. One of the problems with the proposed legislation is that it's being inserted into a provision in Florida law that requires notice to be filed against a media entity before you can file a defamation lawsuit. And the purpose of that was to try to avoid litigation. And so if you provide proof that something was wrong in an article, and if you publish a retraction, then they can still sue for defamation to recoup actual damages, but they cannot have punitive damages. And what this statute or proposed statute change would do is take away that protection, take away the incentive to publish a retraction and avoid punitive damages that way, because all it says is if you're provided notice that it's false and you don't permanently remove it from your website, then you can be sued for punitive damages, and it would also basically remove any statute of limitations. And a statute of limitations is a concept in the law that you have to sue to redress your damages within a certain period of time, because memories fade, documents, disappear over time, and they want things resolved when you can still have the evidence for it.
This bill would actually change the statute of limitations from 2 years from the time that something was published to 2 years from the time that someone was notified, a media outlet was notified that something was incorrect, which would greatly extend that period of susceptibility to being sued.
Well, yeah. I mean, it says that it would be a republication. And right now, Florida has what's called a single publication rule. The first time it's published, if you don't touch it, it's not republished every time someone does a Google search and reads it, right? It was there to be read, just like a book in the library is there to be read and someone picks it up and reads it, right? So 10 years from now, if someone notices the article and sends a notice to the publisher that something in it was false, is there a statute of limitation for that?
Yeah. We've got a call from John in St. Augustine. Good morning, John. Go ahead.
Yes, the government shouldn't be telling media outlets what to publish as long as what they're publishing is accurate. So, for example, if somebody's accused of a crime and the fact is that they were accused of a crime and the charges are dropped, but they were still accused of a crime, that's an accurate thing, and the government shouldn't be controlling what the media says. And if the media is, the media should do an update or a correction. But if they're not, then the control on that is the marketplace. People are going to lose trust in that particular media outlet. They're going to ridicule it. They're going to stop paying attention. With all the various social media now that we're no longer being censored, they can be called out and shown that their articles are not being updated or that they're smearing people. There can be bad behavior by the media, but that doesn't mean that the government should come and tell them what they have to say or not say. And that's about all I got to say.
Thanks, John. I mean, one question that pops up is, if you are required to remove an article, or if you feel that you could be sued for reporting on something that hasn't been carried to the final term in terms of, say, a criminal charge, or if somebody's acquitted. You think about cases where people were acquitted at their first trial, Casey Anthony, O.J. Simpson, R. Kelly. Those are all very prominent cases that we would expect the media to be covering. And yet, because they were acquitted, and presumably someone could make the case that those charges were wrong or incorrect, that would presumably fall under this new guidance.
I think you're correct on that. And the caller, John, accurately described what's called the fair report privilege. And so anyone, not just the media, although it's the media who usually relies on it, right? Because that's their job to report things. But the fair report privilege is to fairly and accurately report on a governmental proceeding, a court case, a document. So if the sheriff's office releases an arrest report, right, and someone says that something in the arrest report was inaccurate, that's not defamation by the media, because the media is just reporting what the sheriff's office is doing and the reasons in the report for what the sheriff was doing.
I'm curious, this is a question my producer had, but I mean, how does this apply to something like the sheriff's office? If they put out on social media, their website, a mugshot, an arrest, they're putting out a notification, that person is later acquitted or the charges are dropped. Would this also apply to them?
Potentially, yes. And there's actually been a lot of litigation about mugshots for that very reason, that they say that it criminalizes them in the eyes of the public. They're usually unflattering, and a lot of people don't want mugshots released for that reason. the opposite end of that is you have to be able to report on who our police officials are arresting, right? That seems a basic function of society monitoring its government,
Hmm.
right? And so you have these countervailing um, principles that are in conflict with each other. And ultimately, if someone reads one article about someone being investigated or arrested, shame on them if they don't do further research and just assume they're guilty, because that's the opposite of what our justice system provides.
There is sometimes some confusion about media, and I want to listen to a comment that was also made at this uh, hearing recently. Democratic Senator Rosalind Osgood was talking about. She voted in favor of this. Let's listen to what she had to say.
If you're a reporter or just a person having a conversation, you should have enough respect about yourself and for your neighbor as well, that you try to investigate, that you don't just hear something. It's like gossiping on the website, and it just goes unchecked. So I'm going to be a yes on this bill, and I hope we get more bills to begin to just let people know they can't just put stuff on websites because they say that they have a freedom of speech.
I want to ask you about that because there are comment sections. There are people who will troll you on social media. There's all kinds of reposting forums for news articles that sometimes people conflate with the actual initial report. And it sounds like perhaps the senator is sort of talking in some ways about both of those things.
Yes, you traditionally under defamation law that we inherited from England and is still the law today, the republisher of false information can be liable for defamation. And that is the law. It's not going to change. And so journalists, when they're preparing their news stories, have to verify facts, because if it turns out that what they're reporting is false, they can be liable for defamation. And I think most of us would agree they should be liable for defamation, right? But if you're reporting on a criminal proceeding, there's no obligation of anyone to go behind and determine if that person is truly guilty before reporting on that criminal proceeding. And likewise for a civil litigation, whether the plaintiff or the defendant is the rightful party, right? Because otherwise you couldn't report on any court proceedings without potential liability for defamation about what you're reporting.
I want to take a call from Dylan in Avondale. Dylan, go ahead.
Hi, thanks. I think what's missing here is the times have changed and the commons are no longer an individual piece of paper like a newspaper that I receive and then throw away. They're infinite. So many decisions are based, I do hiring and firing all the time based on HR departments, and we have to historically look at individuals. And this seems to me to be some kind of anachronistic argument that's not taking into account that people's lives can be ruined by incorrect information. I certainly respect the media. I think it's so important. But I find this argument to be almost technical, without the kind of compassion for individuals who have been, shown to be innocent. I'd like the speaker to talk about how she would feel if this kind of thing had happened to her, and it would then impact her life and her future and her family's future. That's my question.
Certainly, there is always the argument, Jen, that times have changed, right? And this is a different era because the internet is forever, because everybody has access. It's not like I'm going down and looking at the microfilm from 10 years ago. I'm looking at a story that was posted 10 years ago, and I can do it from my keyboard, and it does affect my job prospects. So what, to his point, what would you say about that? I mean, do we need to come to a modern interpretation of what is appropriate in terms of just acknowledging the life of the internet?
Well, just like there was an impracticality of going to a library to cut out the articles from a newspaper or to take down every book. This statute does not require a final judgment in a court of law that the article was defamatory, right? the media loses their fair report privilege defense, essentially, if they don't take it down by mere notice. So anyone with an agenda who hires an attorney to send a notice that says it's false triggers this statute, right? And I think that the callers are saying that if it's been found to be not true, and that's not at the notice period.
So it's one thing if some case has gone to its final conclusion, somebody has been exonerated, you receive a notice and you're asked to take it down. But you're saying that just if I object to this story, maybe if I don't even have an attorney and I send a notice to a local news outlet and I say this story's wrong, that counts as notice for you to take it down as a news outlet. That's what this law would basically mandate. You'd take it down or you would be subject to defamation lawsuits.
Yes. More importantly, you don't have what the notice provision does now is says if you correct it, if you publish a retraction in as prominent a location as the original article, then the person who is defamed cannot seek punitive damages, right? And punitive damages are just to punish people for purposefully doing bad things, right? And that makes sense in that context. But this statute would take away that. It would allow people to sue for punitive damages. So this type of legislation will increase litigation, and frankly, it'll increase politically motivated litigation. People with an agenda who want to drive what is the quote unquote truth. And so if there's any kind of what Sam Morley said, if there's any kind of update that needs to be made to the story, it needs to be after the judicial proceedings.
And it's worth noting that this law would apply not just in Florida, but for anything that's published that affects somebody that lives here in Florida could file suits. So there's this concern about litigation tourism. I just want to take a call from Eric. Eric, go ahead. Eric, are you there?
Hi.
Yeah.
My concern is about... Hi, can you hear me?
Yep, go ahead.
My concern is about lying politicians. There's an asymmetry between what is demanded of the press and what's demanded of a politician who knowingly lies. If a politician were forced to retract what is known to be a lie, it might be a fair law. But without that, the politician as an individual can claim protection of the First Amendment and claim he doesn't know it and claim that he has the freedom of speech. And that's the problem. When you deprive the press of that freedom, but you don't deprive the individuals of that freedom, you have a radical asymmetry that's very dangerous.
Thanks, Eric. Jen, we're going to have to leave it there. Just final thoughts for people to consider.
I think the argument about the internet being a new age and making things different is true in the sense that people don't have the privacy, the ability to hide from the media as much because everyone has access at their fingertips. But on the other hand, they also have access to all the follow-up information. So like I said at the front end, the ability to research what happened in the end is easier now today than ever before.
Yeah. Well, Jennifer Mansfield, thank you so much for being here. Really important conversation.
My pleasure.
All right. Up next, we come back. A man sits on death row today based on the testimony of a lying witness and jailhouse informants who later recanted. Here to tell us about her story is Nichole Manna, investigative reporter at the Tributary. Welcome, Nichole.
Hi, thank you for having me.
This is an extraordinary three-part story that just landed this week, and I know you've been working on it for a very long time. But start us off, if you can, about kind of bring us up to speed on Kenneth Hartley. He's on death row. He was accused in a 1991 murder case, and a case that the prosecutor at that time even called weak when he first got it.
Correct. In reporting this story, it's all from public record requests that I got. And in one of those public record requests is the prosecutor's notes that says, must talk to victim's family about weak case. Kenneth Hartley has been on death row since 1993. He was accused of killing 17-year-old Gino Mayhew. And as the prosecutor said at the trial, it was an unsolved murder until this man named Sidney Jones called police and came forward and said, this is what I witnessed. I witnessed the kidnapping. It was the kidnapping that happened before the murder. And so the case kind of went off from that, and they made arrests of Kenneth Hartley and his two co-defendants. At the end of the trial, Kenneth Hartley and Ronnie Farrell ended up on death row. Sylvester Johnson was given life in prison. Ronnie Farrell is now in prison for life. His death sentence was remanded because he was able to successfully argue ineffective defense counsel.
And so Kenneth Hartley, one of these three, remains on death row. His chief witness against him, Sidney Jones, was a really problematic witness for a number of reasons. Can you explain, first of all, who Sidney Jones was, how he got involved in the case?
Yes. So from what we have gathered from the court documents, he called police at some point from jail and said, "This is what I had witnessed." The prosecutor in the trial said Sidney Jones came forward out of the kindness of his heart. We have learned that Sidney Jones actually thought he was going to get paid for his testimony, which kind of reveals his background. He was a paid confidential informant for JSO. I have documents of payment vouchers going back to about 2 years before the murder. I've talked to a local attorney who had documents going back to 1970 who said Sidney Jones was financially backed by the Jacksonville Sheriff's Office. On top of that, Sidney Jones was a witness in a 1979 murder case completely separate from this, on the stand, went to trial, gave testimony, and then almost immediately recanted that testimony after he left the stand. And said, "I lied, I made that up." And he was convicted of perjury. He got 3 years in prison. 10 years later, that goes to the Florida Supreme Court. They overturned that perjury conviction on a technicality, saying that the judge erred in not bringing Sidney Jones back to the witness stand. But that doesn't mean that Sidney Jones didn't lie. So he was still a liar after that decision. None of this was disclosed by prosecutor George Batay to the defense or the jury.
So basically, the prosecutor in this case used someone who'd been prosecuted and convicted of perjury as his chief witness in this case and didn't tell the defense.
Exactly. And Sidney Jones was the only witness to this alleged kidnapping that happened. The second witness had alleged that he just passed by Gino Mayhew's vehicle, saw Ronnie Farrell in it, and another man.
And so Sidney Jones, in addition to being a known perjurer, he had actually become such a problem for his handlers at JSO that they stopped trusting his testimony. And in fact, you found a payment voucher from JSO to him as a confidential informant, and scrawled across it in huge black letters, it just says blackballed.
Yes, so that word is on the payment voucher and his what looks to be almost an application to become a confidential informant. We don't know when that was written. It just, on the dates, appears that it could have been before the trial. The last payment voucher that I have been able to find from him was a few days before the murder took place. But we were never able to connect exactly when he was blackballed. We're also kind of unable to connect exactly what that means. And I found in this slew of requests that I made an email that a former JSO detective sent to an attorney in 2008 that says Sidney Jones is lying, POS. And, nobody will admit to why he was blackballed to this day.
Yeah, and so that was somebody that had worked with him, this detective that called him a lying.
Yes,
Yeah. So, this is part of his record as somebody who was not reliable previously, but we know from your reporting that he also lied at trial, that he testified to the jury that he was a 6-time felon. He was actually a 9-time felon with 4 misdemeanors. How significant? I mean, there's a pretty high bar, as you say, for having any impact on a death case. Generally, higher courts don't like to reverse a jury verdict.
Yes, yeah. And I've talked to a couple of attorneys who do this, pro bono, who look at death penalty cases and bring them forth for appeal here and in other states. And they say, in where Kenneth Hartley is in the process right now, his attorneys have to prove that this information could not have been available to him before and was not available to him before. It's called right for review. So they have to make sure that their argument in the appeal is new and hasn't been argued before. So the argument really hinges on this Sidney Jones and his background, how that was never disclosed to the jury, and these 3 informants that you mentioned earlier. Of the 3 informants, 2 have died since, but 2 of them, one before he died, recanted their testimonies in various ways and said, we made up our testimony. And one went as far as to say, I was given the information that I needed to testify to. That was backed up by signed sworn affidavits from other inmates who were in the Duval County Jail with these men from 91 to 93. And I was able to actually talk with one of them myself, who also confirmed that the jail was this hive of informants in the 90s, and everybody was looking to jump on a case.
Yeah, and I want to get more to that in just a moment about why people would be volunteering themselves to, serve as a witness in a case. But first, I just want to ask you about this disclosure. You report that the prosecutor, George Patay, he was asked by the attorney, the defense attorney in this case, Hartley's attorney, whether any of the witnesses in this case had a history of perjury. And you report that the prosecutor said he didn't know and the attorney should just try to find out for himself.
Yes. So these documents are very common in murder trials, and I'm assuming most other trials, where the defense attorney will ask, like, I want to know your witness's criminal history. They ask the perjury question, and then the response, this is all through documents. And the response from George Patay was unknown to us, but you can look for yourself. And it's interesting because I have talked to prosecutors who said of that time, it's not impossible for a defense attorney to find history of witnesses, but it's really hard. And then I have talked to defense attorneys who said it's almost impossible in the 90s. We can't just go on Google and Google search Sidney Jones. And so it would have been completely unknown to them if that was not disclosed. So that's part of the argument that's ongoing now, is whether or not this prosecutor broke what's called Brady violations by not disclosing favorable evidence to the defense team.
And it was that prosecutor's office who had prosecuted the perjury case. So it's not, it would not have been unknown.
Right. I mean, and that's a major question I've had is, how, if he didn't know, how is that the case? Because, not only was it his office, he was a prosecutor in that office at the time. He wasn't on the perjury case, but he was in that office, and they fought that all the way to the Supreme Court.
So you spoke to George Patay in your reporting on this. You spoke to basically everybody that was still alive and willing to talk. And he didn't necessarily comment on your findings, but you did present your findings to him.
Correct. Part of my process was I wanted to make sure that there were no surprises in this story. So anybody who's mentioned in the story who is still alive, for instance, Detective William Bellina died in 2017. So can't talk to him. So everybody else, I, tried to be really diligent in making sure they knew exactly what was going to be in this story. Mr. Patay declined to answer my questions and to comment on any of that, but he had the findings before publication, and he offered the comment that is in the story that is just kind of an overall about his career as a prosecutor and how he always, tried to be fair and felt that he was fair and honest.
So let's talk about his career as a prosecutor, because that's sort of the second part of this 3-part investigation. He worked at the prosecutor's office for more than 30 years. He retired in 2008, and he had a reputation of being a very aggressive prosecutor. Some people thought that he crossed the line on some occasions, and in fact, he had a couple of cases remanded by the Florida Supreme Court because of prosecutorial misconduct.
Yes. So 2 of those cases happened after the Kenneth Hartley conviction. And in both of them, he had been admonished for certain statements he made during closing arguments, statements that the Florida Supreme Court said dehumanized the defendant. And those remand, that led, to, it's so complicated, that led to the Florida Bar, a different entity, to then open up an investigation of their own into those cases. And they were the ones that said, we're not going to reprimand you here. There's not a case for reprimand for us to do that. But, please don't cross or go to the line again, was kind of essentially the letter that they sent him.
It was interesting, too. He was represented in his in that case by an attorney of his own.
Yes.
And that attorney's argument as to whether these statements were appropriate or inappropriate that dehumanized the defendants, His response was, he's done this in 20 cases.
Yes.
This is not isolated. This is not a unique event, and you've never complained about it before.
Yeah, I thought that was really interesting to admit, like, oh, yeah, these things that you're admonishing for him now, he's done before, like 10 to 20 other times. And in those cases, if you could go back to the Supreme Court website and read through all of them, there are actually objections made by the defense counsel in that case. So it does make me wonder how those other cases, went by. Were there objections to what he was saying? Kenneth Hartley, I believe, at some point used both of those cases as an argument in an appeal, but the Supreme Court did not agree with Kenneth Hartley's arguments in that case. And at that point, I believe the makeup of the Supreme Court, the Florida Supreme Court, was also different.
Sure. And you spoke to a number of people on and off the record for this story. We should say that you spoke to some people that defended George Patay and his conduct and his performance at the state attorney's office vehemently. You talked to former mayor and former prosecutor John Delaney, who said, who defended him and said that, he was a very ethical and very, reliable person. And he sort of said that, if people are saying something nice about a prosecutor, defense, that they're always going to criticize a prosecutor. If they say anything nice about a prosecutor, it's because the prosecutor's soft.
Yeah, that seems fair, and kind of what I gathered from this. And if a prosecutor is talking really good about a defense attorney, it seems like maybe that defense attorney is also soft. So it was interesting to see that going both ways.
Yeah. The reliance on jailhouse informants, however, was a hallmark of this particular prosecutor. You found that there were people who said that he used jailhouse snitches in virtually every major case that he had. These are people that worked with him. One gentleman who's known him since childhood, essentially, and said that even, though he worked side by side with him as a prosecutor, that he'd used, a confidential informant or a jailhouse snitch in one case, and he thought that George Patay used them to almost an extreme.
Yes, I've talked to so many people who have said, oh, every single case that he was on, he was using informants. And Mr. Patay was the type of prosecutor that was taking on the hardest cases and the worst crimes. So that you have to imagine that means every single one of his homicide cases used an element of informants. And one attorney I talked to, Rick Sikta, actually said that one of the informants in the Hartley case had been used as an informant by the state attorney's office in 2 other cases. One of those cases was prosecuted by George Patay. So it's interesting that this almost like cycle of informants continues to be used.
And we know that was a different era. You talked to people back at that time saying, inmates had full access to the TV, to the newspapers. They were very familiar with the contents and the findings in a criminal case, and were therefore in a unique position to offer up case information that would appear to be, informed, reliable. Why was there such a reliance at that period on confidential informants, jailhouse snitches, and has that changed?
I think with Kenneth Hartley's case, the issue is that there were no witnesses. There was just this liar, Sidney Jones. There was one other man who had some sort of testimony that multiple people have now said scientifically couldn't be correct. He couldn't have actually seen what he said he saw. So when you have nothing else to go on, jailhouse informants are the next best place because they're with your defendant, and the allegation is that they talk to each other, and it's pretty easy to bring an informant who's already in custody onto a witness stand. And it's easy because they knew, and this was said by the informant, or not the informant, the inmate that I had talked to, and then all of the other inmates who signed affidavits, that they knew that they could get a deal. In fact, one of them said that everybody in the jail knew the state attorney's office was always open for business back then.
A lot in this story, too, about the rewards that people got for this kind of testimony. Nichole Manna, her story is available at jaxtrib.org, a 3-part series, extraordinary reporting. Thank you for being here.
Yeah, thank you.
All right, up next, 10 people with 5 minutes and a story to tell.
Ascension St. Vincent's and WJCT present Healthy Hearts and New Starts, Understanding Cardiovascular Health and Weight Loss Surgery with Drs. Cunningham and Bailey, March 25th at WJCT Studios. Event is free, but registration is required at wjct.org/events.
Hi, it's Tom Hudson, host of the Florida Roundup on Fridays at noon, and we have a special edition soon. We'll be live in Jacksonville on April 4th. We'd love to have you there. It's free and lunch is included. Information and register at wjct.org/events.
On the next Fresh Air, the New Yorker staff writer Andrew Marantz joins us to discuss how podcasts, streams, and YouTube channels have become the platforms where men who feel disillusioned and alienated go to feel seen and heard, with many of them gravitating toward the MAGA movement. Join us.
Today at noon on WJCT News 89.9.
Social upheaval and political unrest happens all around the world, and sometimes it's the catalyst to change those countries for the better.
Some of the best solutions came out of the darkest times in these countries' histories.
I'm Meghna Chakrabarti. Natasha Hakimi Zapata joins us to talk about what a polarized U.S. might learn from other countries in Another World is Possible. That's on the next On Point.
Today at 11 on WJCT News 89.9.
Affordable childcare remains a dream for millions. New data says childcare now costs more than college tuition in most parts of the country. For parents who have the means to pay, and plenty can't, why has childcare become so expensive? That's next time on 1A.
Today, starting at 10 on WJCT News 89.9.
Welcome back. Well, my next guests know something about cramming a great story into just a couple minutes, so let's get at it. I'm joined by two veteran Story Slam storytellers, Julia Ivanisova. Welcome, Julia.
Hi.
And Melanie Rodriguez. Welcome. So both of you are primarily visual artists. I'm curious, Melanie, how did you get into like a storytelling mode, and how different is it from the visual work that you do as an artist?
I've always been a very dramatic person.
Mhm.
And I met Babs because Cork Studios, which is a giant warehouse in downtown, most of the studios in the warehouse are visual art. And they had a giant event where all the artists were showcasing their artwork. And I went there for my visual interest and found Babs on this little booth talking about a thing called Story Slams, and I was instantly hooked.
We should say Babs is Barbara Colacello. She's the one who organizes these Story Slams. She's been on this program a bunch before. Julia, you're also telling stories in a second language. How difficult is it to be participating in a Story Slam when your native language is Ukrainian?
Yes, English is my third language. I know Ukrainian and Russian. But my English, it's still not very good, and it really was very challenging when I comes. And we have improv classes in Babs Lab, and this has helped me to be more confident and to tell the stories. I think maybe 2 years before, I even can't imagine that I can perform on the stage.
Yeah, and you actually won, I guess, second place at a recent Story Slam.
Yes.
Yeah, so wonderful. And Melanie, I think you won a Grand Slam. Is that right?
Yes, the last Grand Slam for 2024, I had been telling stories all year, every month, and I got in because of a technicality. And I ended up
Take
winning.
it. It's
Yeah.
okay. What do you find works as a storyteller? What do the audiences respond to best?
Audiences come to hear stories to feel like they're not alone. So I find on the Story Slam that I won, it wasn't a huge extravagant story. It was like little old me in my room reading a comic. But for me, it was like the most important thing then, because imagination is so important, and being in my own space and using my imagination is so important, and you lose that over time. And I guess that struck a chord in people, And I think that's why, one, people want to be brought back to a place that maybe they haven't been back in a while.
Yeah. And so stories can be very small and intimate. And yet, Julia, you had to flee Ukraine during the Russian invasion. And so you have
Yes.
stories that are really quite
Yeah.
powerful and also very significant.
Yeah, some of them reflect my experience from Ukraine when a war began. And I do some art about this. I tell stories about this because it's really very hard, but a very important part of my life.
Yeah. What do you get out of storytelling personally?
Uh, I think I feel a big support from people here when I tell the stories, and it's like healing for me when I can to share this experience and to tell what happened. It's really very important for me, and I'm very happy that so supportive and nice people come to Bob's Lab. I always like this experience.
Yeah. The theme of this upcoming story slam, Melanie, is Rebel Bloom, and it's sort of celebrating stories of transformation and resilience. Do you go with a story in mind? Do you know what you're going to be speaking about?
Yes. I have been open 2 years. I have a medical massage studio here in Jacksonville, and opening that up, being open, getting it to a place of success has been a challenge for me, especially as a young woman. I've had to kind of like pull myself up by the bootstraps, despite a lot of commentary in my direction and a lot of predisposed ideas of what massage therapy is.
Mhm.
So succeeding and not having, I guess, that community to back me up has felt like rebelling and blooming all at the same time.
Yeah. How about you, Julia? Do you have a story in mind when you go?
Yes, I will tell a story about when war began. We moved with my another friend to one part of Ukraine was what was not so dangerous. However, we was in the beginning, and we begin some business with Ukrainian symbolic and Ukrainian art on the T-shirts, and we do some charity from this business, and this business very healing us. Like we not think so much about what happened around us, and we focus on the doing something to help another people and to do some, like it was little my art too, because I create all these designers in Photoshop, and it was like I say that art always heal myself.
Yeah. Well, the event is at Babs Lab. It's the March Story Slam. It's this Friday, tomorrow,
Yes.
at 7:30 to 10:30 on King Street. You get tickets at barbaracolicello.com/register. We got a link on our website because that's a lot to spell. Thank you so much for being here, Julia, even Isava. Thank you, and Melanie.
For First Coast Connect is provided by Baptist Health and the North Florida TPO.
Baptist Health is a proud supporter of First Coast Connect. Baptist Health, committed to building a healthier community for all of us. More info at 202-4YOU or baptistjacks.com. The North Florida TPO is dedicated to transportation planning, funding, clean fuels, and new technologies for a vibrant, resilient, and connected.
Child care for one infant now costs more than a year of in-state college tuition in most states. How are families managing?